So we are discussing about the disablement. The disablement, we have to continue with the definition. So the disablement can be partial disablement or total disablement. The partial disablement can be classified as temporary or partial. If the disablement is temporary, it means that for that time where he was engaged in the employment, he is not able to earn for the period, maybe 1 month or 2 months. Whereas the disablement of the permanent nature, it can reduce all time his earning capacity in every employment which he was capable of undertaking at that time. So here, in case of partial or complete permanent disability, the earning capacity will be reduced for the time period if it is temporary, and for the life if it is permanent. Now, deemed to be permanent partial disablement, Part 2 of Schedule 1 contains the list of injuries which shall be deemed to result in permanent partial disablement, and complete and permanent loss of the use of any limbs or member referred to this in schedule shall be deemed to be the equivalent to the loss of that limb or member. So the total disablement can also be classified as temporary total disablement and permanent total disablement. Total disablement means such a disablement, whether of a temporary or permanent nature, which incapacitates the employee for all the work which he was capable of performing at the time of accident, and due to the accident which resulted in the disablement. So coming to the employee's liability for compensation, it is dealt under Section 13, subsection 1. So before we discuss the liabilities of the employers, what is the definition of compensation? So the compensation is defined under Section 2, 1C of the Act, which means that the compensation as provided for by this Act, and the Section 3 of the Act provides for the employer's liability for compensation in case of occupational disease or personal injuries, and that prescribes in the manner in which his liability can be ascertained. Okay, so even the occupational diseases are also considered for the compensation. In case of occupational disease, where an employee employed in any employment specified in Part A of Schedule 3 contacts any disease specified therein as an occupational disease peculiar to that employment, and contracting the disease shall be deemed as an injury by accident arising in the course of employment. And where the employee employed in any employment specified in Part B of Schedule 3 for a continuous period of not less than 6 months under the same employer, and in the service contract, any disease which has been specified in the Part B of Schedule 3, and the contracting of such disease shall be deemed to be an injury by accident which has arisen in the course of the employment. So if an employee while in service, if one or more employers, not necessarily it can be the same employer, in any employment specified in Part C of Schedule 3, for such continuous period as the central government may specify, and he contracts any disease even after he ceased to be in the service, it is also considered as occupational disease. And if it is proved that the employee, while in the service of one or more employers of his employment, specified in Part C of Schedule 3, has contracted a disease which is specified therein as an occupational disease during that continuous period for which he was working, it will be categorized as an injury by accident while performing the occupation. So, except as mentioned, no compensation shall be payable to any employee unless it is mentioned in Part C or Part B of Schedule 3 as an injury or a occupational disease. Now, what is the compensation? Schedule 3 and 2 of Section 4 of the Act have specified the temporary and the permanent disability and the diseases related. So the Schedule 2, it consists of the list of persons engaged in different employments it can be operation specified, or it can be the definitions wherein who can be covered as an employee and who is entitled for a compensation. So, a person employed for loading and unloading of materials in a factory or a ship, persons employed in work incidental or connected with the manufacturing process. And Schedule 3 contains a list of occupational diseases which, if contracted while in employment, entitles an employee for a compensation. Now, what is the amount of compensation under Section 4, subsection 1, where the injury results in death of a person? An amount equal to 50% of the monthly wages of the deceased employee multiplied by the relevant factor, or an amount of rupees 1,20,000, whichever is more. The maximum amount may go up to rupees 4.56 lakhs. And if it is a permanent total disablement resulted from an injury, an amount equal to 60% of monthly wages of the injured employee multiplied by the relevant factor, and an amount of rupees 1,40,000, whichever is more, and the maximum compensation may go up to 5.48 lakhs. And the compensation to be paid when due and penalty for default under Section 4A. So if the employer fails to pay the amount of compensation, or maybe if the employer does not accept the liability for the compensation to the extent which has been claimed, so the provisional payment is based on the extent to which the liability which he accepts. And such payment shall be deposited with the commissioner or made to the workman, as the case may be, and without prejudice to the right to the workman to make any further claim. Where any employer is in default in paying the compensation under this act, within 1 month from the date it fell due, the commissioner shall direct as per Section 4A, subsection 3, A and B. Now, how do you calculate wages? Where the employee has a continuous period not less than 12 months immediately preceding the accident, he is in the service. The employer who is liable to pay compensation, the monthly wages of the employee shall be 1/12 of the total wages which has fallen due for the payment to him by the employer in the last 12 months of that period. And where the whole of the continuous period of service is less than 1 month, the monthly wages of the employee shall be average monthly amount which during the 12 months immediately preceding the accident. And in other cases, in which it is not possible to calculate the monthly wages shall be 30 times the total wages earned in respect of the last continuous period of service. So, a period of service shall be deemed to be continuous, which has not been interrupted by a period of absence from the work exceeding 14 days. Then it is considered as continuous period of work. Now, review of half monthly payment, Section 6 of the Act provides that any monthly payment payable under this act, either under an agreement between the parties or under the order of a commissioner, may be reviewed by the commissioner. And it is based on the application either by the employer or the employee. And it has to be accompanied by the certificate of a qualified medical practitioner that there has been a change in the condition of the employee, or subject to rules made under the act. So, any half monthly payment may on review under the above provision be continued, or it can be increased or decreased, or it can be closed. Or if the accident is found to have resulted in permanent disablement, and it can be converted to lump sum amount to which the employee is entitled, less any amount which has already received by way of half monthly payment. So if there is any change in the condition, definitely the resultant compensation will also be changed. The term will also be changed. As we have seen the permanent disablement, it was 5.48 lakhs. So that can be paid as lump sum to the employee who has been disabled. or it can be paid after deducting if any amount has been paid as half monthly payments. Now, commutation of half monthly payments, Section 7 of the Act says that any right to receive half monthly payments may be by agreement between the parties, or if the parties cannot agree or the payments have been continued for not less than 6 months, on application of either of the party, that is either employer or employee to the commissioner, it can be redeemed by the payment of a lump sum of such amount as may be agreed by the parties. So instead of paying the monthly, it can be made a lump sum payment as well. Distribution of compensation. No compensation has to be paid in respect of an employee whose injury has resulted in death, and no payment of such lump sum compensation to a woman or a person under a legal disability except to deposit with the commissioner. The employer cannot make any payment of compensation directly to the deceased legal heirs. So, whenever there is a death occurred due to the disability or due to the injury, the amount has to be deposited with the commissioner. The amount cannot be paid directly to the legal representative or legal heir. Now, compensation not to be assigned as per Section 9. So, as provided by this Act, no lump sum or half monthly payment payable under this Act can be assigned or charged or attached or passed to any person other than the employee by operation of law, nor can any claim to be set off against the same. So, it cannot be assigned. Now, coming to the penalties for the offences under the Act, if he fails to maintain a notice book, which is required to maintain under subsection 3, fails to send the commissioner a statement, which is required to send, he fails to send a report, which is required to be made under section 10B, fails to make a return, which is required under section 16, shall be punishable with a fine of minimum 50,000 to maximum rupees of 1 lakh. There's no prosecution under this section except with the previous sanction of a commissioner. No court shall take cognizance of any offense under this section unless a complaint has been made within 6 months of the date on which the alleged commission of the offense came to the knowledge of the commissioner. Other than that, we have miscellaneous provisions, form of application as per section 22 subsection 1. Whenever there is an accident occurs in respect of which the liability to pay compensation under this Act arises, a claim for such compensation may, subject to the provision of this Act, be made before the commissioner. Now, the power of commissioner to require further deposit in cases of fatal accidents, where any sum has been deposited by an employer as compensation payable in respect of a workman whose injury has resulted in death, and in the opinion of the commissioner, such sum is insufficient. So the compensation, whatever is paid in case of a death to the employee, the commissioner feels that it is insufficient. The commissioner may, by notice in writing, stating his reasons, can call upon the employer to show cause why he should not make a further deposit within such stipulated time. And if the employer fails to show cause to the satisfaction of the commissioner may take up an award determining the total amount payable and the required amount which has to be deposited by the employer for whatever the deficiency is there. All costs incidental to any proceedings before a commissioner shall be subject to the rules made under this Act, will be at the discretion of the commissioner. Now, registration of the agreements where the amount of any lump sum payable as compensation has been settled by agreement, whether by way of redemption of a half monthly payment or otherwise where any compensation has been made to so settled as being payable to a woman or a person under a legal disability, a memorandum shall be sent by the employer to the commissioner, who shall, on being satisfied as to its genuineness, record the memorandum in a register in the prescribed manner. An appeal shall lie to the court from certain orders of a commissioner as mentioned in the Act. as per Section 30, subsection 1. The power of the state government to make rules is dealt under Section 32, subsection 1, and the rules made by the central government to be laid before the parliament as per Section 36 before the total period of 30 days, wherein it may be comprised of one session or two or more successive sessions, and before the expiry of the session, immediately following the session or the successive sessions. So both the houses should agree in making such modification to the rules, or both houses agree that the rule should not be made. So only then the rules can be changed. So this is what all about the Employee or Workmen's Compensation Act. Coming to the next, Employee State Insurance Act 1948. Now here, the Employee State Insurance Act 1948 provides for certain benefits to the employees. It can be in case of sickness, maternity, and employment injury, or also it makes certain provisions, some matters related therein. And the need is every worker is liable to fall victim to the contingencies of life, like it can be illness, it can be injury and death, so on and so forth. So in such a scenario, the affected worker may find himself unable to report the duty, unable to earn for his livelihood, unable to earn his money and maintain his family. And in case of the death of the worker, his departments may have nothing to fall back upon. So a worker of small means may find himself completely shattered economically because of no earnings. So it is therefore the responsibility of the employer, the trade unions, the state, or we can say all of them who have to come forward and rescue the worker from his economic and physical distress. So the Employer State Insurance Act was passed in the year 1948 to fill the vacuum, and the act provides safeguards to the workers against the various illness or evils of the society like diseases, dirt, ignorance, so on and so forth. The act is an assurance to the worker that in case there is a reduction or loss of earning capacity due to illness, disablement, either it can be a partial or permanent, maternity, old age, unemployment, or loss of income to the members of the family of a worker in case of his early death. So, or his dependents in case of his death, the minimum requirements will be taken care of Article 41 of the Constitution of India. So it lays stress on providing such kind of a social security. And what is the object and the scope and coverage? So the Act provides for certain benefits to the employees in case of sickness, maternity, and employment injury. Scope and coverage, the Act extends to whole of India. And to non-seasonal factories employing 10 or more persons also it applies. And these are extended to area-wise stages. And the Act contains an enabling provision under which the appropriate government is empowered to extend the provisions of the Act to other classes of establishments such as industrial, commercial, agriculture, so on and so forth. And the applicability of the Act, the central government is empowered to enforce the provisions of the Act by notification in the official gazette to enforce different provisions of the Act on different dates and for different states or for different parts thereof. So coming to the definitions, we have the appropriate government, which means central government in respect of the establishment, or it can be the state government in case of other cases. Confinement means labor resulting in the issue of a living child or a labor after 26 weeks of pregnancy, resulting in the issue of a child, whether alive or dead. Contribution is the sum of money payable to the corporation by the principal employer in respect of an employee, includes any amount payable on behalf of the employee in accordance with the provisions of the Act. Corporations, it means employee state insurance corporation set up under this Act. A dependent under Section 2, subsection 6A of the Act and which has been amended by the Employees State Insurance Amendments Act 2010, means any of the following: a widow, a legitimate or adopted son who has not attained the age of 25 years, an unmarried legitimate or adopted daughter. It can be a widowed mother. It can be a wholly dependent on the earnings of the injured person at the time of his death, a legitimate or adopted son or daughter who has attained the age of 25 years and is infirm, and if wholly or in part of the dependent of the insured person at the time of his death, a parent other than a widowed mother, a minor illegitimate son, an unmarried illegitimate daughter, or a daughter legitimate or adopted or illegitimate if married and minor, or if widowed and a minor brother or an unmarried sister, or a widowed sister of a minor, a widowed daughter-in-law, a minor child of a predeceased son, a minor child of a predeceased daughter where no parent of the child is alive, or a paternal grandparent if no parent of the injured is alive. So this is the definition of the dependent. So if you have seen even the Workmen's Compensation Act, we have seen the dependent definition and it is more or less the same. Now, employment injury, if a person means a personal injury to an employee caused by an accident, or it can be an occupational disease which has arisen out of or in the course of his employment. And being an insurable employment, whether the accident occurs or the occupational disease is contracted within or outside the territorial limits of India. Now, who is an employee? Any person employed for wages in limits of India or in the connection with the work of a factory or establishment to which this particular act applies. It also includes clerical, manual, technical, supervisory functions. And who is an exempted, before that, employee earnings, wages up to 15,000 per month are covered under this act. And apprentice is covered under the Apprentices Act 1961. And any number of Indian naval, military, or air forces are not within the preview of this particular act. And coming to the exempted employee, it means an employee who's not liable to pay the employee's contribution. Principal employer, who is he? It can be in a factory, owner or occupier of the factory. It also includes the managing agent of such owner or occupier, the legal representative of a deceased owner or occupier, where a person has been named as a manager of the factory under the Factories Act 1948. In any establishment under the control of any department of any government in India, the authority appointed by such government in this behalf, or where no authority is so appointed by the head of the department. So, what is a family? It means relatives of an insured person, and it can be any of the following: a spouse, it can be a husband or a wife, a minor, legitimate, or adopted child dependent upon the insured person, a child who is wholly dependent on the earnings of the insured person who is receiving education till he or she attains the age of 21, an unmarried daughter, a child who is infirm by the reason of a physical or mental abnormality or injury and is wholly dependent on the earnings of the insured so long as the infirmity continues, dependent parents. A factory where defined or amended by the Employee State Insurance Amendment Act 2010. A factory is a premises including the presence thereof whereon 10 or more persons are employed or were employed on any day of the preceding 12 months. And in case of the manufacturing process, which is carried down ordinarily, uh, but does not including a mine subject to the operation of the Mines Act 1952, or a railway running shed, or it may be noted that the terms of manufacturing process, occupier, and power shall be having the same meanings which has been assigned under the Factories Act 1948. And who is an immediate employer in relation to the employees? Employed or through by him means a person who, under supervision of the principal employer, has undertaken the execution of the whole or any part of the work of a factory or premises. And this is within the said factory premises and includes a contractor who has lent or let on a person's service to the principal employer. Now, what is an insurable employment? It means an employment in the factory or an establishment under which the act applies. Who is an insured person? It means a person who is or who was an employee in respect of the whom the contributions are or were payable under this act. Manufacturing process is defined as per the Factories Act 1948. Occupier is also having the same meaning assigned as per the Factories Act 1948. Permanent partial disablement, it means the disablement of a permanent nature which reduces the earning capacity of an employee, which he was capable at the time of the accident and which resulted in the disablement. And permanent disablement where he is permanently disabled and it incapacitates the employee to work the work which he was capable of performing at the time of the accident. Now, seasonal factors, it means a factory which is exclusively engaged in one or more of the following manufacturing process, such as it can be cotton ginning, cotton or jute pressing, decorations of groundnuts, manufacture of coffee, indigo, lace, rubber, sugar, including gur or tea or any manufacturing process which is incidental or connected with any of the aforesaid processes and includes a factory which is engaged for a period not exceeding 7 months in a year. Any process of blending, packing and repacking of tea, any process, manufacturing process as per the central government's notification under the official gazette. What is sickness? It means a condition which requires medical treatment and attendance, and it will always necessitate the absence of the person at work on medical grounds. Temporary disablement, it is a condition resulting from an employment. It can be an injury or occupational which requires medical treatment and renders that the employee is temporarily incapable of doing the work which he was doing prior to or at the time of injury. Now, what are wages? Wages means all remuneration paid or payable in cash to an employee in terms of the contract of employment. Now, coming to the registration of the factories and establishment, Section 2A of the Act lays down that every factory or establishment to which the Act applies shall be registered within such time and in such manner as may be specified. Now, employee state insurance. Section 38 of the Act makes compulsory that the subject to the provisions of the Act, all the employees in factories or establishments to which this Act applies shall be insured in the manner provided by this Act, and such insured persons shall pay contributions towards the insurance fund through their employers and will also pay their own contributions. Such persons will be called as an insured person. Now, the administration of employees' state insurance schemes. For the administration of the scheme of the employees' state insurance in accordance. State insurance in accordance with the provisions of this Act, the Employees State Insurance Corporation Standing Committee and Medical Benefits Council have been constituted. Further, the ESI fund has been created, which is held and administered by ESI Corporation through its executive committee called Standing Committee and with the assistance advice and expertise of medical counsel, etc. Now, the Employee State Insurance Corporation is defined under Section 3. So, this provides the establishment of Employee State Insurance Corporation by the central government for the administration of the Employee State Insurance Scheme in accordance with the provisions of the Act. Now, the Constitution, Section 2, Subsection 4, the central government may appoint a chairman, a vice chairman, and other members who will be representing the interest of the employers, employees, state governments, union territories, and medical professions. The three members of the parliament and the director general of the corporation are its ex officio members. Now, coming to the creation of the Employees State Insurance Fund, how is it created? Section 26 of the Act provides that all the contributions paid under this Act and all other money received on behalf of the corporation shall be paid into a fund, which is called as Employees State Insurance Fund. And this shall be held and administered by the corporation for the purposes of this particular Act. Now, the purpose for which this fund may be expanded is the payment of the benefits and the provisions of the medical treatment and the attendance to the insured persons. It can be the payment of fees and allowances to the members of the corporation. It can be the standing committee, the medical benefit council, the regional boards, local committees, regional and local medical benefits council. And it can also be covering the payment of salaries, leave, joining time allowances, traveling and compensatory allowances, gratuities, and compassionate allowances, pensions, contributions to the provident or other benefits, establishment and maintenance of hospitals, dispensaries, and other institutions, payment of contributions to any state government, local authority, or it can be the defraying the cost, auditing of the accounts of the corporation, valuation of the assets and liabilities, and it can be employees insurance quotes which have been set up under this act, any expenses relating to that, payment of any sums under any contract entered into the purpose of this act by the corporation of the standing order committee, payment of any sums under the any decree or award, defraying the cost and other charges of instituting or defending any civil or criminal proceedings. It can be the expenditure within the limits prescribed or any other such purpose the corporation may, with the previous approval by the central government, contribute. Now, the contributions have to be paid at such rates as may be prescribed by the central government. The present rates are 4.75% and 1.75%. 4.75% will be paid by the employer and 1.75% will be the contribution made by the worker. The principal employees paid contribution in the first instance, according to Section 40 of the Act, it is upon the principal employer to pay in respect of every employee, whether directly employed by him or through any other immediate employer, have to make the contributions. According to Section 39, subsection 5, if any contribution payable is not paid by the principal employer on the date on which such contribution has become due, he shall be liable to pay simple interest at the rate of 12% per annum or at such higher rates as may be specified. Now, the recovery of the contribution from immediate employer, this is dealt under Section 41. Principal employer who has paid contribution in respect of an employee employed through an immediate employer is entitled to recover the amount of contribution so paid, both the employer's contribution as well as the employee's contribution. So how much is the percentage of contribution? As I said, it is 4.75 and 1.75. So these can be recovered by from the immediate employer. Now, the method of payment of the contribution, the manner and the time of the payment of the contribution, the payment of the contributions by means of adhesive or the other stamps affixed or impressed upon books, cards, or otherwise. The date by which the evidence of contributions have been paid is to be received by the corporation. The entry in or upon the books or cards with the particulars of contribution paid and also the benefits distributed in the case of the insured person to whom such books or cards relate. The issue or sale or custody or production, inspection, delivery of books or cards, and the replacement of the cards. Now, coming to the benefits, these are laid down under section 46. Periodical payments in case of sickness certified by a medical practitioner. Periodical payments to an insured workman in case of a confinement or miscarriage or sickness arising out of pregnancy or confinement. Periodical payment to an insured person suffering from disablement as a result of employment injury. Periodical payment to dependents of insured person. Medical treatment and attendance on insured person. Payment of funeral expenses on the death of insured person. And this is at a specified rate, fixed rate. Now, what are the authorities and their duties, powers? The following have authorities under the Act, like the inspectors, authorized officer, recovery officer, medical board, medical appeal tribunal, employees insurance council, appeal to high court, reference to high court. So the duties and powers and the procedures of the authorities as per section 45, 55 are mentioned, etc. are mentioned. So the inspectors, the corporation may appoint such person as the purpose of this act within such local limits as may be assigned, and he has the provisions like he might ask for the information from the immediate employer to furnish the details. At any reasonable time, he may enter the office, factory, or premises, and he has the power to verify the books, the documents, and such other information. He has right to examine the principal or the immediate employer or the agent, make copies or take extracts from any register. He has the excise, the power or to uh, question, to take, to ask questions and get the details in certain cases. And he also has such functions and such exercises what he can perform, which he is authorized, which he may be authorized by the authority. Now, who is an authorized officer? It means the Director General, Insurance Commissioner, Joint Insurance Commissioner, Regional Director, or such other officer who can be authorized by the central government with a notification in the official gazette. And the recovery officer, he is, it means any officer of the central government, state government, or the corporation who may be authorized by the central government by notification in the official gazette to exercise the power of a recovery officer under this act. Now, the coming to the medical board, any question pertaining to the determination of disablement, whether accident has resulted in the permanent disablement or whether the extent of loss earning capacity can be assessed provisionally or finally. And medical appeal tribunal, the insured person or the corporation, if is not satisfied with the decision of the medical board, he might appeal to the medical appeal tribunal in the prescribed time with the prescribed provisions. Now, employees insurance court, the insured person or the corporations have a further right to appeal in the prescribed manner within the prescribed time to the employees insurance court or directly to the employees insurance court whenever there is any issue relating to the disablement or the benefit or the commuted value. And the review of the decision by the medical board or medical appeal tribunal will be, if it is satisfied by fresh evidence, the decision was given to the consequence of the non-disclosure or misrepresentation by the employee or any other person of the material fact. And the review of dependents benefit, any decision awarding dependents benefit under this act may be reviewed at any time by the corporation if it is satisfied by the fresh evidence. And institution of proceedings before the employees insurance court, the court will take up the case, and if the court is satisfied with any fresh evidences or any proceedings pending before it can be conveniently dealt, and the insurance court can be, the employees insurance court in the same state can be taking up the matter, and the state government may transfer any matter pending before any employees insurance court in the state to any such court in another state with the consent of the state government of that state. And commencement of the proceedings before the employees insurance court. So whatever the proceeding shall commence by the application, which shall be made within a period of 3 years from the date of the cause of the action. And the application shall be in such form, it shall contain all the particulars or the details accompanied by such fee as prescribed by the rules which have been made by the state government. And no court which is in the dispute between the principal employer and the corporation in respect of any contribution or any other clue shall be raised by the principal employer in the employee's insurance court unless he has deposited with the court the 50% of the amount due from him as claimed by the corporation. Now, the court has all the powers of a civil court for the purpose of summoning, calling the workers, enforcing the attendance of witness, compelling the discovery and the production of the documentary evidences, material objects, taking oath. So all these powers are best with the insurance court. And an employee of insurance court may submit any question of law for the decision of the High Court. If it does so, it shall decide the question pending before it in accordance with such decision. Stay of payment pending appeal, where the corporation has filed any appeal against the employee's court order, that court may, if so directed by the High Court, shall pending the decision on the appeal. And appeal to the High Court, an appeal shall lie to the High Court from an order of an employee's insurance court. And if it involves any substantial question of law, the period of limitation for an appeal shall be 60 days. So within such 60 days, the period of limitation for an appeal will be there. Coming to the prosecutions, no prosecutions are instituted except by with the provisions of section of the insurance commissioner. No court inferior to the metropolitan magistrate or judicial magistrate of the first class shall try any offense under this act except on a complaint made in writing in respect thereof. Now, coming to the liabilities, every principal and immediate employer shall submit to the corporation such returns in such a form containing such particulars relating to the persons employed and in relation to his factory or establishment. And every principal officer or employer shall maintain registers or records in respect of his factory or establishment. And no employer, by reason of his liability for any contribution payable, shall directly or indirectly reduce the wages of an employee or reduce the benefits of an employee. No employer shall dismiss or discharge or reduce or punish employee during the period of employee whenever the employee is in maternity or disablement or sickness or any other absence. And where an employer transfers the factory or establishment in a whole or in part by sale or gift or lease or license or in any other manner whatsoever, the employer and the person to whom the factory or the establishment is so transferred shall be jointly and severally liable. So these are the penalties. So imprisonment up to 6 months or fine up to rupees 2,000 whenever, whether knowingly, makes a false statement or representation for the increase in the payment of benefit. Failure to make any contribution, imprisonment up to 3 years and a fine up to 10,000. The minimum period of imprisonment can be varying from 1 year. Deduction from wages of an employee, the whole or the part of the employer's contribution. Minimum 6 months to 3 years of imprisonment and a fine of rupees 5,000. The same punishment, the same penalty is there for the dismissals, discharges, fails or refuses to submit any return, or he obstructs any officer or inspector in entering the premises. And if it is guilty of any contravention, same punishment, that is 6 months to 3 years imprisonment and a 5,000 rupees fine. And subsequent offense, if the offense has been repeated, minimum 2 years to maximum 5 years of imprisonment and a fine of rupees 25,000. And the same offense committed again, then imprisonment up to 2 years and a fine of rupees 5,000. So the miscellaneous provisions say that the corporation shall be a body corporate. The corporation, in addition to the insurance scheme, It also promotes measures for the improvement of the health and welfare of the insured persons. And the standing committee of the corporation persistently defaults in performing their duties or abuses its power, the central government, by notification in the official gazette, supersede the standing committee or the corporation shall submit an annual report, and the annual report and the audited accounts of the corporation together with the report of the comptroller and the auditor general of India. And any contribution payable under this act may be recovered as an arrears of land revenue. And the corporation may, with the approval of the state government, establish and maintain in such states, hospitals and the dispensaries and other medical and the surgical services what it thinks fit. The right to receive any payment or any benefit under this act shall be not transferable or assignable. And where a person is entitled for any benefit provided by this act shall not be entitled to receive any other similar benefit. And where any person has received any benefit or payment under this act when not lawfully entitled shall be liable to repay the value. And any application or appearance of the act made or done by any person to the employees insurance court may be made or done by any legal practitioner or by any other officer. So uh, whenever the deceased, there's a case here wherein the application, appearance, or act required to be made is done by any person before the employee state insurance court may be done by the legal practitioner only. So this is the case where it says the judgment wherein the interest as the compensation has been paid. So coming to the next particular subconcept, Employees Provident Funds and Miscellaneous Provisions Act 1952 and the Payment of the Gratuities Act 1972. Now coming to the Employees Provident Fund, again, is a social welfare legislation which has been intended to protect the interest of the workers employed in the factories and other establishment. So we have the Employees Provident Fund Organization, EPFO of India. So we also have the Employees Provident Funds and Miscellaneous Provisions Act 1952. And what is gratuity? It is a voluntary payment made by the employer to the employee in recognition of continuous meritorious service and sincere efforts by the employee towards the organization. And we can see the condition is for the payment of the gratuity, the person should be having more than 5 years of service in the organization. Then only the Payment of Gratuity Act 1972 is applicable. Now, coming to the Provident Fund schemes for the benefit of the employees, it has been introduced by some organization where there is no legal legislation requiring them to do so. So such schemes were, however, have been there only for the limited classes or groups of employees. So in the year 1952, the Employees Provident Funds Act was enacted to provide the institution of Provident Fund for workers in 6 specified industries. And this has been later extended to other industries and the classes of establishment. So the act is now applicable to the employees who are drawing pay not exceeding rupees 6,500 per month. So the need for the act prior to the enactment of the Employees Provident Fund Act, Miscellaneous Provisions Act 1952, the worker has no means of earning his livelihood during the old age, nor due to the low wages who could save something for his old age. And in old age, what really happens is the person becomes sick and he is dependent upon his children. And the moment he's a dependent, the situation is worse. So for that purposes, the Provident Fund, the Miscellaneous Provisions Act 1952 was passed, which will try to suffice the old age dependency. Now, coming to the commencement and objective, the Act was passed to provide for the institutions of provision funds. It can be pension fund and deposit linked insurance fund. for the employees in the factories and other establishments. So the major purpose of this act is to make some provisions for the future of the industrial worker once he retires, and the dependents in case of early death. Commencement and scope: the Employees Provident Funds and the Miscellaneous Provisions Act came into force in the month of November 1952, and it extends to whole of India, covers factories and other establishments where 20 or more people are employed, and subject to the certain conditions, even if the employees are less than 20 employed, it can be applicable. Now, coming to the applicability, to every establishment which is a factory engaged in industry specified under Schedule 1, where 20 or more persons are employed. In any other establishment employing 20 or more persons or class of such establishments, which the central government may by notification in the official gazette specify in this behalf. Now, the non-applicability. Section 16, subsection 1 of the Act provides that the Act shall not apply to certain establishments as stated under such establishments include establishments registered under the Cooperative Societies Act 1912, any other law for the time being in force in the state relating to a cooperative societies, employing less than 50 persons and working without the aid of the power, to any other establishments belonging under the control of the central government, to any other establishment set up under any central provisional state act, whose employees are entitled to the benefits of the contributory fund or old age pension in accordance. So you cannot cover yourself under the acts from the different states and take multiplicity of the benefits. If you're taking the benefit at one place, you are not entitled to take the benefit in other provisions. Now, the appropriate government, it can be the central government or it can be the state government. The basic wages means all the emoluments which are earned by an employee while on duty or on leave or on a holiday, and which are paid or payable in cash to him, and does not include any cash value of food, concession or any dearness allowance. Uh, and this is to say that all the cash payments by whatever name called paid to an employee on account of a rise in the cost of living. So house rent allowance, overtime allowance, bonus, commission or any other similar allowance payable to the employee in respect of this employment will not fall. And of work done in such employment, any presents made by the employer, presents or gifts. Contribution means the contribution payable in respect of a member under the scheme of the contribution payable. And controlled industry means an industry, the control of which by the union has been declared by the Central Act to be expedient in the public interest. An employer, in case of an establishment, it can be a owner or a person or an agent who has the power to run the business or the factory. And in relation to any other establishment, the person who has the authority which gives him the ultimate control over the affairs of the establishment. An employee means any person who is employed for wages in any work. It can be a manual or it can be in connection with the work of an establishment for which he gets wages directly or indirectly from the employer. And it includes a person employed through a contractor, a person who is engaged as an apprentice, but not being an apprentice engaged in the Apprentices Act 1961, and who is an exempted employee to whom a scheme or the insurance scheme, as the case may be, would not be granted, but for the exemption granted under the Section 17. Exempted establishment, it means an establishment in respect of which an exemption has been granted under Section 17. A factory means a premises including the part where the manufacturing process is carried out. Fund is the provident fund established under the scheme. Industries, it means an industry specified under Schedule 1 and includes any other industry added to the schedule by notification under Section 4. Insurance fund is a deposit-linked insurance fund established under Section 2, under subsection 2 of Section 6C. Now, insurance scheme, it means that the employee's deposit-linked insurance scheme framed under Section 1 of Section 6. Section 6, subsection 1. Manufacture and manufacturing process, it means any process for making, altering, repairing, finishing, packing, oiling, washing, cleaning, breaking, or demolishing. So any other thing which can be treated of adapting, made to an article or a substance. Sorry. A member means a member of the fund. Occupier of a factory means a person who has ultimate control over the affairs of the factory. Pension fund means the employee's pension fund. Pension scheme means the employee's pension scheme framed under Section 6, subsection 1. Scheme means the employee's provident fund scheme framed under Section 5. Superannuation in relation to an employee who is the member of a pension scheme, which means that he has attained by the under the employment terms an age of 58 years. Now, coming to the employees' provident fund schemes, which is dealt under Section 5, subsection 1, the central government may, by notification in the official gazette, may frame a scheme to the employees' provident fund scheme, and this will be an establishment of provident funds under the Act for the employees or for the class of the employees, and specify the establishment or class of the establishments. Now, coming to the central board, under Section 5A, subsection 1, the central government, by notification in the official gazette, constitute with the effect from such date as may be specified, a board of trustees for the territories to which this act extends. And then we have executive committee, Section 5, AA, subsection 1, deals with the central government may, by notification in the official gazette, constitute with effect such date as may be specified therein an executive committee which will be assisting the central board in the performance of its functions towards the pension. Now, coming to the employees pension scheme, we will continue this in the next class. So if you have any doubts, students can ask me. I think it's only Vaishnavi again. So any doubts, Vaishnavi?
No, ma'am.
Okay, then. So we'll continue from here in the next week,
Okay, ma'am.
right? Okay.
Oh, thank you, ma'am.
Okay, ma'am.